Thank you. And I would note one of the reasons why the left and the Chinese communists resort to litigation is because their ideas are incredibly unpopular when the American people vote on them. So, for example, in the United States Senate, every Senate Democrat voted in favor of the California waiver that would effectively ban the internal combustion engine in 18 states across the country. Every Senate Democrat voted in favor of it, but you know what? The citizens aren't voting in favor of it. They're not campaigning. We don't see our Democrat colleagues saying we're going to ban the internal combustion engine. Even in bright blue states, even in Vermont and Rhode Island, the voters are not saying take away the car out of my driveway. And yet, Democrat office holders are trying to use government power to fight the Democrat wishes of their electorate. General Kobach, let's talk about the courts. The Climate Judiciary Project, backed by the Environmental Law Institute, Energy Foundation, and private donors connected to plaintiffs' law firms, has trained over 2,000 judges, many in key jurisdictions where these climate cases are pending. Is it appropriate for sitting judges to receive climate science, quote-unquote, education from advocacy groups like the Environmental Law Institute, groups that are directly tied to the plaintiffs in active litigation?
Hey everyone, welcome back to the channel. If you're new here, I'm your independent political analyst. No spin, no tribalism, just facts and thoughtful commentary on what's really going on in Washington. Today, I'm reacting to a fiery exchange on Capitol Hill that centers on climate change litigation, judicial ethics, and allegations of political indoctrination. The video we're covering features senators, legal experts, and advocates discussing the Climate Judiciary Project program that trains judges on the science and law surrounding climate change.
No, Mr. Chairman, I do not believe it is any more than it would be appropriate for a group of justices to go on an extensive training conference and be trained in how to dispute or defend the fossil fuel industry. When you have a group of litigants in a pitched legal battle in approximately more than 3 dozen cases, if we're talking about more than just the ones brought by cities and counties, the judges are there to be neutral. And the worst thing I fear going into any case on any issue is if I know that the judge is already dug in based on prior things the judge has done or said against me. So, I don't think it's appropriate for litigants to be training the judges in essentially what their experts are going to say in the trial.
Mr. Chairman, may I respond to this as well?
No, because we've got limited time if someone else wants to get into it. General Kobach, isn't it true that... Actually, go ahead, Mr. Arush.
Well, I just wanted to say that what Mr. Kobach is saying he opposes is exactly what's happening from the defense side as well. The Environmental Law Institute has multiple oil companies on its board, executives of oil companies, BP and Shell, and it has counsel representing them in court in important leadership positions.
So we may be breaking news here. Are you, on behalf of Public Citizen, calling for the Environmental Law Institute to stop training judges and indoctrinating judges?
What I'm saying is it doesn't make any sense to say that they're indoctrinating judges as some sort of leftist plot.
Okay, let's be clear. I'm calling for them to stop training judges because I think they are indoctrinating them. It's interesting you said that, but you weren't willing to go to the natural next step of, therefore it should stop.
I don't know that much about it, but I do know that BP and Shell are on the board.
Mr. Arush, if you believed what you were saying, you would be willing to call for it to stop. You're not, and that suggests you know damn well what it is they're training the judges, and it's indoctrination, and you don't want it to stop because you want the judges to be biased and rule in favor of these crackpot theories. Now, General Kobach,
BP and Shell are on the board of an organization.
Isn't it true,
judges against them.
Mr. Arush, your time is done.
Thank you.
Isn't it true that these programs, often hosted in conjunction with the Federal Judicial Center or the National Judicial College, can obscure ethics disclosure requirements because they fall under judicial exemption categories?
Yeah, I think, Chairman, you're correct. There are definite ethical problems, and in addition to the overarching sort of federal model of ethics, you also have additional state ethical rules that may be violated as well. But at the end of the day, it's judicial neutrality that is the biggest ethical constraint on our entire Article III courts and state courts, and that is the biggest problem I see going into any case.
It's also been reported that the Chief Justice of the Hawaii Supreme Court participated in these sessions at the same time that his court was reviewing one of these climate lawsuits. So active litigation, and yet happily being indoctrinated by interested parties in an ex parte sitting where the opposing counsel had no opportunity to refute the indoctrination. Mr. Walter, the Climate Judiciary Project tells judges that climate lawsuits are a, quote, unique opportunity for accountability. Would you call that education, or would you call that political indoctrination disguised as training?
Accountability is the standard term used by political activists to try to say, we want to hurt those folks that we're opposed to.
Do you believe Congress should investigate whether these trainings are undermining the impartiality of the judiciary?
Absolutely, Senator.
Thank you. Senator Whitehouse.
Well, the funny thing about this conversation is that time did not begin.
Let's break down what happened and, more importantly, what it means for the bigger picture of judicial independence and environmental policy. Senator Ted Cruz opened with strong criticism of Senate Democrats for supporting what's known as a California waiver provision that allows states to adopt stricter vehicle emission standards. Cruz argues this could lead to a de facto ban on internal combustion engines in 18 states. His main point? That this kind of aggressive environmental regulation is not something voters are clamoring for. Even in deep blue states like Vermont or Rhode Island, he sees it as politicians pushing an agenda that hasn't been clearly endorsed by their constituents. Now, whether you agree with his framing or not, Cruz is tapping into a real tension in climate policy. How much should lawmakers push transformative environmental laws when public opinion, or at least behavior, doesn't fully reflect that urgency? Then Cruz shifts gears to focus on the courts. This is where it gets controversial. He raises concerns about judges being trained by the Climate Judiciary Project, which is backed by groups like the Environmental Law Institute and private donors, some of whom are tied to plaintiffs in ongoing climate lawsuits. General Kris Kobach agrees, saying this kind of training crosses ethical lines. Judges, he argues, are supposed to be neutral, not trained by groups with a clear stake in litigation outcomes. And that's a fair concern. Judicial neutrality is the bedrock of our legal system. If the public begins to believe judges are being swayed, whether by activists or industry lobbyists, that trust erodes quickly. But then we hear a counterpoint from Mr. Arush, who argues that the same Environmental Law Institute also includes representatives from oil companies like BP and Shell. He questions a narrative that these trainings are purely left-wing indoctrination. This is important context. If judges are being educated by organizations that include both environmental and fossil fuel interests, the picture is less black and white. But here's where it gets interesting. When Cruz asks Arush if he's calling for these trainings to stop altogether, Arush avoids giving a definitive yes. That moment becomes a flashpoint. Cruz accuses him of wanting biased judges, one sympathetic to what he calls crackpot theories. Cruz also brings up the issue of ethics disclosure. These programs often fall under judicial exemption categories, meaning they don't always have to be reported like other forms of compensation or influence. And that's a real issue. Even if these sessions are well-intentioned, the lack of transparency can undermine confidence in judicial fairness, especially when we find out that the Chief Justice of Hawaii attended one of these sessions while his court was hearing a related case. That's not a good look, even if technically legal. So what's the bottom line? Both sides raise valid concerns. If climate cases are the court, and they are, judges do need to understand complex scientific and legal issues. But that education must be unbiased, transparent, and free from the influence of litigants. This shouldn't be a partisan issue. Judicial integrity is something we all rely on, regardless of how we feel about climate change policy. Congress might want to take a closer look, not to score political points, but to ensure that our courts remain above the fray. What do you think? Should judges be trained by third-party organizations at all? Or does that open the door to undue influence? Drop your thoughts in the comments. I read them all. And if you found this breakdown useful, don't forget to like, subscribe, and hit that notification bell so you never miss an update on what matters most in Washington. Thanks for watching, and I'll see you in the next video.